Real estate is divided in a Michigan divorce. Again, you have to conduct the analysis on whether or not the real estate is marital property. If it is marital property, hopefully your client and the opposing party will agree on some sort of either buyout of the residential property, or they can agree to a sale where the proceeds are either divided 50-50 or divided under some other percentage basis according to the parties' wishes. How are retirement accounts such as 401ks and pensions divided in a Michigan divorce? Great question. The retirement accounts, so a 401k, will be divided according to the marital portion, 50-50. It is statutory. Same for a pension. So you can have a marriage of 20 years, and let's say the husband has a 401k that is about 30 years old. Therefore, he's paid into that 401k for 10 years before he got married to his wife. When that 401k is being divided, you would exclude typically those first 10 years because it's non-marital. Oftentimes, lawyers and their clients agree to use what's known as a qualified domestic relations order, which is agreed to by the parties and is typically written after the divorce judgment is entered. And the qualified domestic relations order, often known as a quadro, that's what we all say, quadro. The quadro directs the plan administrators and the overseers of the 401k at the particular person's job or their pension how to divide those funds. But typically it will be 50% of the marital portion. How are debts divided in the state of Michigan? Debts are divided basically how property is divided. You want to ask yourself, is this a marital debt? If it's a non-marital debt, it's going to stay with the person whose name it's in. If it's a true marital debt, like a mortgage, it's going to typically be 50-50 unless there's circumstances that would justify a non-50-50 division of the debt. How are vehicles and personal property divided in the state of Michigan? Vehicles are typically going to stay with their respective owners. What you're going to find in reality in the state of Michigan, two spouses each drive a car, and each spouse is typically going to be okay with the other spouse taking their car that they typically drive out of the divorce, and that will become their property. That's what normally happens. Now, under the law, though, the rules of property still apply. The vehicles are marital property if they were obtained after the marriage. So technically, if there is a $200,000 Lamborghini in the driveway, and heart surgeon husband just purchased a $200,000 Lamborghini and the wife filed for divorce, well, the wife is going to feel that $200,000 was part of the marital estate, and she's correct. That Lamborghini or Ferrari will be divided. Can gifts and inheritances be considered marital property? Only if you're unwise enough to commingle them with the marital estate. Gifts and inheritances are the two most common exceptions to the marital property rule in the state of Michigan, which is that after the marriage, property is marital generally. So a gift from a friend or a parent or an inheritance from deceased relatives is going to be sole property. My advice is to keep that separate if you want it to be separate. Not everybody wants their gifts and inheritances to remain separate either, though. And I think that is always a important discussion for spouses to have.